Hi, I'm Alan from InsureYourCompany.com. Today's topic is the do's and don'ts of hiring and firing. The coverage that can protect your company from legal action is called Employment Practices Liability Insurance. Having that coverage is a plus, but having the knowledge and procedures in place to prevent issues is a lot better. Matching a job to a person, hiring them, can be a very stressful and difficult task. There are candidates that meet the needed requirements, and there are candidates that simply do not. Finding the right person for a position means telling people that they're hired and telling a lot more that they don't have the job. What we'll talk today about is what you can and cannot say. While we can stop someone from complaining or filing an action because they feel slighted in what we said, having an understanding of the law and record keeping will make it easier to defend you. There are many people that make a living applying for positions not really wanting the job. What they're doing is looking for recruiters and hiring managers that do not have the proper tools and knowledge with regards to what they can and cannot say. This lack of information can result in lawsuits and cost you and your company hundreds of thousands of dollars. So when you receive a resume for a position, the following things should never prevent a person from obtaining the job. You are also not allowed to ask about the following things, so don't. You can't ask their age, their gender, their religion, sexual orientation, nationality, disability, health status, marital status, citizenship. You can ask if they're legally allowed to work in the U.S., and for certain jobs, a U.S. citizen is required. You can ask a person's education, experience. You can ask for references, if they have adequate transportation to get to the job, if they speak a certain language, if a certain language is required. If there is a company dress code, you cannot stop them because of their religion from wearing certain clothes or headdresses. I'm sitting in New Jersey, so the laws of New Jersey apply. In this state, it's an at-will employment state. So an employer doesn't need a reason to dismiss an employee. What I do need, however, is to make sure I document all communications with employees. I keep all emails, making notes of all conversations and phone calls, no matter how incidental. Having a record. Having a file will provide the documentation the insurance company and attorneys need to properly defend you. If there is a standard process for reviewing your prospects and for hiring and firing, you need to follow that process. If you don't have one, maybe it's a good idea to make one up. If a prospect calls you up complaining, you need not talk to them. You simply ask them to send you an email or letter. Make note in the file. If there is a claim in the future, having a dated file will enhance your position in a court of law. By following the information that I've just laid out, that'll give you a foundation to prevent employment practice claims. Knowledge is power, and I hope I've empowered you today. This is Alan from InsureYourCompany.com. I'll be talking to you.